Hello, and welcome to another episode of the Women's Voices in Business podcast, a presentation of the Private Corporate Counsel Program at CPLS-PA. In the Private Corporate Counsel Program, our business attorneys, consultants, and mediators help entrepreneurs and executives make their business dreams a reality. It's like having your own in-house counsel and more without the high cost. Visit privatecorporatecounsel.com to learn more. Today, I'd like to start with a story. So imagine this scenario. A well-known, expensive restaurant in Palm Beach County that caters to the rich and famous hosts an after-hours holiday party for its employees. Alcohol and illegal drugs are openly consumed on the business premises in the presence of the business owners, management, and employees. The party becomes increasingly noisy and disorderly. At one point, one employee sexually assaults another employee. What are the potential legal consequences for this employer? Well, in this episode, we're going to hear from Attorney Mary Cannon. She's a business lawyer who works with us in the Private Corporate Counsel Program at CPLS PA. And previously, she worked on an actual employment law case that involved such a fact pattern. She will explain the perils of sexual harassment in the workplace and other costly mistakes that employers need to avoid. We'll be right back with Mary Cannon. So now let's jump right in and talk with Mary Cannon about harassment in the workplace. Mary, what is harassment in the workplace?
Yeah, we always think it's best to just kind of jump in with a general definition. One of our phrases that we use around here at PCC is you don't know what you don't know. So it's best to just jump in with the basics. So quick definition of harassment in the context of employment discrimination. It's any conduct that violates the following laws. We've got Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act of 1967, and the Americans with Disabilities Act of 1990, also known as the ADA. So a brief definition would be it's unwelcome conduct based on race, color, religion, sex, including sexual orientation, gender identity, or pregnancy, national origin, age, older age beginning at age 40, disability, or genetic information, including family medical history. These are all protected classes.
Okay, that's really important. So definitely harassment, it's not just sexual harassment. I think people have heard of sexual harassment, but you can there's harassment based on all those categories that you mentioned. So that's really important.
Absolutely.
And definitely harassment becomes unlawful where enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. So those are the two circumstances where harassment becomes unlawful. And I think it's important for our audience to hear that the anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or lawsuit under these laws, or opposing employment practices that they reasonably believe will discriminate against individuals in violation of these laws. So tell us more, Mary.
Yes, well, that's something that's going to come up in our fact pattern today. And it's a really interesting case. I'm excited to dive into it. One thing we want to clarify is that petty slights, annoyances, isolated incidents, unless they're extremely serious, generally do not rise to the level of illegality. We want to note that to be unlawful, the conduct must create a work environment that's considered intimidating, hostile, or offensive to reasonable people. So there is a certain bar that needs to be met to be considered, illegal conduct. Mm-hmm. Some examples: offensive jokes, slurs, epithets, name calling, physical assaults or threats, intimidation, ridicule, mockery. insults, put downs, this should be common sense, but sometimes it just needs to be stated officially. These are things that as a business owner, you don't want to be participating in, and you want to make it very clear to your entire team that this is not acceptable. We don't want you or managers or anyone within your group engaging in this type of behavior. We want to note as well that the victim is not only the person who's on the receiving end of this type of conduct, it is in fact everyone around who is present or being affected by this type of conduct. So, that is not only the actual victim, but indeed the entire staff. We want to note that the harasser can be a supervisor, it can be a coworker, it can be a non-employee, regardless. As a business owner, you need to be aware of what's going on, and ultimately the buck stops with you. So keep in mind that the victim is not only the person being harassed, but in fact everyone affected by the offensive conduct, and that it can be conduct that takes place by a supervisor, it can be a coworker. And finally, there does not need to be any kind of economic injury to the victim. Simply being harassed in the first place is enough to assert a claim.
Right. And so this is really important stuff for employers to be aware of. And I think one of the things we want employers to keep in mind is that prevention is actually the best tool to eliminate harassment in the workplace. So what can you do as an employer? Well, you can clearly communicate to your employees that unwelcome harassing conduct will not be tolerated. And to do this, you can establish an effective complaint or grievance process, provide anti-harassment trainings, and really, this is really important, take immediate and appropriate action when an employee complains. The bottom line is employers should strive to create an environment in which employees feel free to raise concerns and are confident that those concerns will be addressed. So we can never, guarantee elimination of all lawsuits, but prevention, those kinds of affirmative steps will make a big difference. So now, Mary, let's go back to that case I mentioned earlier about an assault that occurred at an exclusive restaurant in Palm Beach County. Tell us more about what happened.
Yes, well, jumping back into what you said about retaliation, that's an aspect of this fact pattern here today. There are several things that went wrong in this case. It all starts with the owners, of course. This was an exclusive restaurant for the rich and famous, and it was owned by a man and a woman, so they were co-owners of this restaurant. And in fact, the staff lived on property in dormitories. So just to kind of break down a few of the issues here, the complaint was asserted by a female employee who suffered, various harassment, assault, battery, while employed by this restaurant. Let me just pull out the complaint here and we can kind of go over some of the facts. So, the owners were a man and woman, and the woman, in fact, was having a relationship with a different employee, a male employee, who then went on to assault the plaintiff in this case during a staff party put on by the owners of the restaurant. So this was done completely with the owner's knowledge and approval. After hours, they allowed staff to kind of take over the restaurant, use it as a private venue for a staff party. There was open illegal drug use, alcohol was flowing, all that stuff. And predictably, something bad happened. There was a sexual assault where one of the male employees attacked a female employee. To make matters even more complicated, this male employee was in a relationship with the female owner. He was her boyfriend. And when the victim of this terrible assault and battery stepped forward, she went to the police, she went to her employers seeking assistance. And instead, what happened? The owner of the restaurant wanted to protect her boyfriend and gave him the heads up, the cops are coming, you need to get out of here. So she basically interfered with that investigation, she prevented his arrest, and on top of it all, she retaliated against the female employee for making the report in various ways. It goes on from there. There's actually more to it than that, but that's just a little brief introduction into what we're talking about today.
Wow. And so this is an actual case. So
yes.
What claims were asserted against the employer?
So just to name a few, I mean, we've got the assault, we've got the battery. In fact, we have 2 of each, because in addition to the assault that took place on the night of that party, as well, our female plaintiff in this case had another relationship with a different male employee. This was her boyfriend that she was in a long-term relationship with. In fact, they lived together in a cabin as part of this staff dormitory. And, when she decided she was ready to end this relationship because he was, not the nicest guy, it was a bit of an abusive situation as well. He basically told her point blank, well, I'm the manager, the owners, they really rely on me, and, you're finished here if you leave me. So that was his threat to her. And that did turn out to be the case. She moved out of his cabin and into the women's dormitory, and promptly her hours were reduced to almost nothing. So
sounds like retaliation.
Well, yes, because it had to do with her relationship with this other employee and some of the abuse that was going on there, and the fact that she distanced herself from him. She also reported it to the owners. But as he was their manager, predictably, as he had told her, they kind of saw him as, oh, we really rely on this guy. And, we're going to kind of brush off what the woman has to say in this particular incident. And in fact, we're going to try to silence her by reducing her hours and punishing her for coming forward. So those were some of the claims. We've also got discrimination and harassment on the basis of gender. We've got intentional infliction of emotional distress. And then on top of it all, unpaid wages. They had wage and hour claims. They were not paying her properly. So many mistakes were made. Really silly things that, as attorneys, we shake our heads at, but that's what we're there for, is to kind of guide people and hopefully prevent some of these mistakes.
Yeah, so what lessons can be learned from this case?
I think number one is to have a good team around you to kind of keep an eye on things and make sure you're not getting into trouble. I think that these business owners, I don't necessarily think they're bad people, but I think they really did not have the proper guidance that they needed. And with the right team around you, someone is there to say, hey, please, do not get into this relationship with your employee. When this incident happens, take it seriously. Let's have some consequences. Let's assist in the police investigation. These are the type of things that we see as common sense, but of course, I think it's helpful to have a team around you. And as well, something that I want to emphasize is that business leaders are community leaders as well. Business leaders have an obligation to treat their employees with respect and courtesy. And that affects the community at large. So we are business leaders, we are community leaders. We need to conduct ourselves accordingly.
Right. It's not only because it's legally you're required to have an appropriate workplace, but it's also the right thing to do.
That's right.
It's the right thing to do for yourself, your employees, and your community. So, Mary, thank you for telling us about this case. That is a really good example that shows some of the mistakes that employers could make if they're not aware of these anti-harassment laws. Can you think of any other examples of mistakes that employers might make and that we'd like them to be aware of?
Of course. It all starts at the hiring process, I would say. So the interview process even is somewhere that employers need to be very informed of the rules. It's easy to make mistakes if you're not informed. There are certain questions, even during an interview, before you even employ somebody, that you are not allowed to ask. And it starts from there. It continues with the onboarding process. And of course, in the day-to-day, I think employers have an obligation to themselves, to their staff, and the community to just be informed, know what the law is, and try to do the right thing at all times.
Right, and that's a good business practice.
Correct.
That's what I always like to emphasize too. A lot of times, just being aware and trying to do the right thing and being aware of the laws it's better for your business in the long run.
It goes a long way to just try to do the right thing.
Right. Well, Mary, thank you so much for joining us today and sharing your experience in this interesting case.
It's been a pleasure. Thank you all for having me today. I really enjoyed my time on the podcast.
Well, we'll look forward to having you another time.
Thank you so much.
Thanks again to Mary Cannon for sharing her experiences with us. I think that's really important information that employers need to know about harassment in the workplace. So I enjoyed that discussion. One more thing before we close today. This is going to be our last podcast of the year, and we'll be back in 2023. But since 2022 is coming to a close, I thought I'd mention an interesting article I saw recently in Forbes. The 5 business trends in 2023 everyone must get ready for now. So let's talk about 5 business trends according to Forbes. And then when we come back in 2023, we can kind of be looking to see if what Forbes predicted was correct. So what are the top business trends we can expect to see in 2023 according to Forbes? First, accelerated digital transformation. So we're seeing things, the acceleration of innovations such as artificial intelligence. And according to the Forbes article, to prepare for this, businesses must ensure they embed the right technology throughout their processes. So we're going to see accelerated digital transformation. Trend number 2 we can expect to see in 2023, inflation and supply chain security issues. Experts say we should expect ongoing inflation and subdued economic growth in 2023. Basically, this will be a continuation of the supply chain issues that emerged during the global shutdowns caused by COVID-19 and have gotten worse in the war in Ukraine. So inflation and supply chain security, that's trend number 2. Trend number 3, sustainability. According to this article, the world is increasingly aware that climate change will pose a much bigger challenge than anything we've experienced in recent decades. And the trend that they're reporting is that many consumers and investors prefer businesses with the right environmental and social credentials. So in 2023, businesses should make sure that their environmental, social, and governance processes are moved to the center of their strategy. So interesting perspective. That's number 3. Trend number 4 we can expect to see, immersive customer experience. In 2023, according to Forbes, customers will crave experience above all else. So price and quality is important, but Forbes is stressing that if you look at how customers are choosing their products, they use recommendation engines and so forth. So this will continue to play a key role in 2023. And trend number 5, according to Forbes, is the talent challenge. So over the past year, we've seen huge movements of talented people. This has been referred to as the Great Resignation and quiet quitting as workers reassess the impact of work and what they get out of their lives. So, according to this article, offering people fulfilling work, ongoing opportunities to grow and learn, flexibility, and diverse, value-oriented workplaces will all be essential in 2023. I thought that's kind of food for thought as we close 2022 and look forward to 2023. So we'll look forward to these trends. So just to summarize, today we talked about harassment in the workplace and other costly mistakes that employers need to be aware of. And now we've talked about some trends that employers can expect to see in 2023. If you have a question for us or questions about the Private Corporate Counsel Program, you can definitely call 877-847-7887, or you can email us at info@privatecorporatecounsel.com. And again, since it's our last podcast for 2022, I'd like to thank CPLS PA for making this podcast possible. I'd also like to thank our guests and everyone else who's been involved, including our superb marketing department. Thank you. Our next episode will be in January 2023. We look forward to discussing additional topics of interest to businesses, such as professional communication, entertainment law, and more. See you in 2023.
Please continue listening to our podcast to learn more. Contact us at 877-647-7887 or email us at info@privatecorporatecounsel.com to learn more about the Private Corporate Counsel Program and how we can help you and your business on your journey to success.